Court does call the case of the people versus Daniel Magoo.
Enter to the hearing on the people.
State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523. I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that that charge is invalid on
That
its
we're going
face.
to be addressed. That would be addressed at a preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all 3.
Sir, do
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all dismissal on all these charges.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Ms. Lobby has let me know that all paper discovery has been sent to Mr. Magoo in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case, so they responded to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. Magoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. Magoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a
All right.
speedy
So
trial.
you want your preliminary examination. Those are coming down to the jail to him.
I expected you would have him early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th and
to
then
have him in well.
he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination as being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 4 different counts, or 5 different counts, excuse me, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200, nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case.
Buckle up, guys. Today we are going to dive into a courtroom drama packed with tension and high stakes. Daniel Maku faces multiple charges, from fleeing police and driving under suspension to operating an unregistered vehicle, DUI with prior records, and even escaping lawful custody. Some charges are minor misdemeanors, others carry serious prison time. The courtroom is set for a showdown where every argument could shift the outcome. On paper, Maku's facing years behind bars if things go wrong. From the opening gavel, the stakes are crystal clear: freedom or serious consequences. Each motion, objection, and argument has weight in this legal battle. The tension is palpable, even before the first witness speaks.
On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service. Any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, plus the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is fine plus court costs. Mr. Magoo, yeah, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do, I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor.
Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you.
If
That is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge. Torture, Feaster, Assistant Public.
Hey, Mako takes the bold step of representing himself, testing his understanding of the law and courtroom procedure. He challenges the prosecution on technical grounds, questioning whether his license was properly revoked and demanding the state prove every element of each charge. The court listens but makes it clear that oral motions alone won't dismiss the allegations. Mako is pushing hard, using every legal maneuver at his disposal, showing confidence and strategy. The judge remains firm, balancing fairness with procedure, letting him make his points while keeping control. Viewers can sense the tension. Every word is a potential turning point. This segment shows the high-stakes chess match between a self-represented defendant and a disciplined court. It's a battle of wit, strategy, and legal precision. Maku's challenges hint at the suspense and uncertainty of what comes next.
Public Defender, on behalf of the defendant, I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations. And I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting the release, Your Honor, PR bond.
A response from the people regarding his bond.
People would ask the bond to continue, and he also, I'm sure, failed to appear before judge's place. So
Yes.
that warrant would also hold up with respect to the other. I'll wait. If there are pleadings filed by the defender's office, our office will respond to that. And I guess my one remaining point would be, should with the court's appointment, Eastern the Public Defender's Office, I will make sure that the digital discovery that I referenced is certified on the Public Defender's Office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
That's what I
would
Mr. Choda said.
in any event, but also given the fact that one of the charges is the escape from lawful custody. That in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And,
I understand the presumption of innocence.
and a lot of these are
April
facially
26th.
invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office.
not.
The courtroom drama escalates as Maku invokes constitutional rights, challenging the legitimacy of the escape charge. He argues he was held in a hospital, not a jail, calling into question whether the statute even applies. The judge carefully considers these arguments, weighing due process against procedural fairness, while emphasizing that the charges remain unless formally disproven. This segment underscores the tension between legal technicalities and judicial discretion. Maku presses the court on multiple fronts, highlighting potential delays and alleged violations of his rights. Each objection increases suspense, leaving the audience wondering if his arguments might sway the outcome. The exchange illustrates how defendants can navigate technicalities to challenge the system. Every line builds anticipation for what the court will allow and what will be rejected. Viewers see the delicate balance between strategy and law in action.
I understand.
I was not.
Or the custody of.
I was dropped off at the hospital and they later tacked on
And
charges
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out. And that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me. Including many that I don't even know the connection. Court has.
The stakes spike dramatically as Maku requests release on a personal recognizance bond, arguing that most charges are minor misdemeanors and do not justify detention. The courtroom tension is palpable as the judge evaluates prior offenses, including repeated DUIs, fleeing police, and the alleged escape. Public safety and flight risk take center stage, and the judge ultimately denies bond. Maku remains in custody, underscoring the serious consequences he faces. This moment shows the intersection of law, risk assessment, and courtroom judgment. It's a pivotal point where viewers understand that arguments alone won't guarantee freedom. Every word adds suspense, emphasizing the unpredictability of the legal system. Maku's frustration and the court's firmness heighten the drama. It's a crucial turning point that sets up the next explosive developments. The tension leaves audiences on edge about what he might try next.
This judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I would deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with for me, and as well as the others that I see that are listed there. They will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people, individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So,
I'm aware that such note or such filings were being received by our ethics committee yesterday. At this point, we continue to proceed with this case until I hear otherwise from the elected prosecutor.
Can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are...
All right, everyone, let's take a moment to break this case down from start to finish. Because what we just witnessed inside this courtroom is layered with legal maneuvers, high-stakes accusations, and more than a few dramatic twists. We started with Daniel McCoo standing before the court, facing a long list of charges: fleeing and eluding police, driving under suspension, operating an unregistered vehicle, operating while intoxicated with a prior record, and even escaping lawful custody. On paper, these charges range from misdemeanors with small fines all the way up to felonies carrying years in prison. Right away, you can see why this case matters. The outcome could determine whether Daniel walks away with minor penalties or faces years behind bars. Now let's talk strategy. From the very beginning, McCoo tried to punch holes in the prosecution's case. He claimed one charge, escape from custody, shouldn't even apply because he was being held in a hospital, not a jail. And legally speaking, that's an interesting argument. The statute requires lawful imprisonment, and he's betting the court won't see a hospital as confinement. Whether or not that argument succeeds is up to the preliminary exam, but it's the kind of technicality defense lawyers sometimes use to their advantage. Next, he pushed back on the driving charges. He demanded proof that his license was suspended and that he had been properly notified. He even challenged the prosecutor to prove all three required elements: that he was operating a vehicle, that he was on a public roadway, and that his license was revoked at the time. Again, that's exactly how a defense is supposed to work: attack every element and force the state to carry its burden. But here's where things got complicated. The judge made it clear these arguments couldn't be resolved through quick oral motions. They would have to wait for the preliminary examination. That's where the state will bring forward witnesses and evidence to establish probable cause. Until then, the charges stand. On top of that, there was the issue of discovery. McCoo hadn't yet received critical evidence, including police body cam footage and reports. The prosecutor promised the materials were on the way, but McCoo argued he had prepared for cross-examining officers that day and was ready to go forward. He even invoked his right to a speedy trial. That's a smart move. It signals he doesn't want the state dragging things out. But the court sided with caution, deciding he should have the evidence first. Then came the bombshell: the bond hearing. McCoo asked to be released on a personal recognizance bond, arguing that most charges were misdemeanors and not serious enough to justify continued detention. But the judge wasn't convinced. With prior DUI allegations, fleeing police, and especially the escape charge, the judge labeled him both a flight risk and a danger to the public. That sealed it. No bond modification. Detention continues. And just when it seemed the hearing was wrapping up, McCoo dropped the most unusual twist of all. He filed a civil lawsuit against the judge and other parties. That's right. The very person presiding over his criminal case is now also a named defendant in his civil complaint. It's rare, it's risky, and in most cases, courts see it as a tactic to force recusal. But this judge wasn't budging. He called the filing frivolous, refused to step aside, and warned that McCoo's moves looked more like manipulation than justice-seeking. Now let's step back and consider the bigger picture. What does all this mean? First, it shows the delicate balance of courtroom power. Defendants can challenge the system, file motions, and even sue, but judges have discretion to keep cases on track. Second, it highlights the importance of procedure. You can't just argue charges away on the spot. There are steps, exams, and hearings that must play out. And third, it raises the question of credibility. Will the court see McCoo as a legitimate fighter for his rights, or as someone throwing up roadblocks to delay accountability? And that's where I turn it over to you. What do you think? Was McCoo genuinely raising constitutional issues worth considering, or was he just playing legal chess to buy more time? Do you think the judge was fair in keeping him detained, or should the bond have been lowered? And most importantly, will his hospital escape argument hold up in court? Drop your thoughts in the comments below, because I want to hear where you stand. At the end of the day, the judge set a firm date: preliminary examination on August 19th, 2025. That's when this case will either move forward or start to unravel, depending on what the prosecution can prove. One thing's for sure, this isn't the last time we'll hear from Daniel McCoo, and the next round promises to be just as explosive.
Just when the hearing seems to be concluding, Mako drops a bombshell, filing a civil lawsuit against the judge and other parties. It's an unusual and risky move, often seen as a tactic to force recusal. The judge calls the filing frivolous, refuses to step aside, and makes it clear that court proceedings will continue. This segment wraps the session with high drama, showing courtroom strategy, legal tension, and bold maneuvers. The preliminary examination is officially set for August 19th, 2025, leaving viewers anticipating the next round. The courtroom power dynamics are on full display, illustrating how defendants can test the boundaries of the system. Every line builds suspense, showing that the battle is far from over. This final part leaves the audience eager for updates. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.